After completing this lesson, you will, with regard to the MLC 2006, know the different inspection requirements, and also be aware of the ILO guidelines for inspections by port state control, and also know the general areas to be inspected by port state control, and also know the responsibilities of the master regarding these inspections. To a large extent, initial compliance with the Convention will depend on the ship owner having the right policies and procedures in place to meet flag state requirements. To achieve initial compliance and to be issued a Maritime Labour Certificate will require both the completed Declaration of Maritime Labour Compliance and a full flag state inspection of the vessel. At that stage, there may not have been the opportunity for the vessel to gather sufficient evidence of these policies and procedures having been fully implemented and in operation on board the ship. It will be the master's responsibility to ensure that these policies and procedures are fully implemented, and that evidence is available to satisfy the flag state authorities that the vessel has ongoing compliance with the Convention requirements at the intermediate inspection. The specific detail of the master's responsibilities under the Convention will be dependent on a number of factors. For example, the specific laws and regulations of the member state under which the vessel is registered, and the actual procedures and policies of the ship owner. The general responsibilities are, however, defined by the 14 areas identified in the appendices of the Convention to be inspected by flag state and port state control authorities. The role of the ship's master must therefore include the ability to demonstrate that ongoing compliance is being maintained, and to provide sufficient evidence to satisfy the requirements of the external inspections. The Maritime Labour Convention requires that member states have a system of flag state inspections in place to carry out inspections of vessels flying their flag. Flag state inspections will normally fall into 3 categories. Full-term inspections to confirm initial or ongoing compliance prior to issue or renewal of a Maritime Labour Certificate. Intermediate inspections carried out between the 2nd and 3rd anniversary of the issue of the Maritime Labour Certificate to ensure ongoing compliance. And additional inspections, which must be carried out when significant alterations or modifications are made to the vessel. Other additional inspections may also be necessary in cases where an interim Maritime Labour Certificate has initially been issued, and in those cases where a complaint of non-compliance has been made or non-compliance is suspected. Although the inspections will be focused on the 14 areas listed in the appendices, vessels will be checked for compliance with all of the requirements of the Convention. Port state control inspections are intended to ensure compliance with the Convention by foreign vessels visiting ports of member states that have ratified the Convention. The inspection requirements are applied to all foreign vessels visiting a port of a member state that has ratified the Convention, whether or not they are registered under a ratifying member state under the No More Favourable Treatment clause of Article 5. As with flag state inspections, the areas that port state control must check for compliance are listed in the appendices of the Convention. Vessels will also, however, be expected to comply with all the requirements of the Convention. Port state control inspections may be carried out any time a foreign flag vessel visits a port of a member state. In addition, if investigation of any complaint by port state authorities indicates that there is likely non-compliance, then a detailed inspection may be carried out. It should be noted that under Regulation 521 of the Convention, a valid Maritime Labour Certificate with a valid DMLC attached should be accepted by port state control as prima facie evidence of compliance. Assuming there are no obvious deficiencies or any outstanding complaints of non-compliance, port state control inspectors should accept these certificates without need for further inspection. The master therefore has a responsibility to ensure that valid certificates are maintained and available on board at all times, in order to avoid any unnecessary inspections. Fairness and consistency in the way that inspections are carried out are essential if the aims and objectives of the Convention are to be met. In order to achieve this fairness and consistency, the ILO passed separate resolutions to have inspection guidelines established for flag state and port state authorities. The guidelines, which contain full guidance to the inspectors regarding inspection areas and procedures, and the actions to be taken in the event of non-compliance, were adopted by the ILO in 2008. These guidelines are intended to be used extensively for planning and carrying out inspections under the Convention. Ships are likely to be subject to more frequent inspections by port state control than by flag state. It is therefore essential that masters and senior officers are familiar with the ILO publication, Guidelines for Port State Control Officers Carrying Out Inspections under the Maritime Labour Convention 2006, in order to satisfy the requirements of port state control officers during inspections. In the rest of this lesson, we will consider the 14 areas that are identified in the Convention for inspection by port state control authorities. The 14 areas identified for inspection are also the same mandatory areas of compliance required for certification. It must be remembered that, in addition to these 14 areas identified for inspection and certification, vessels must also comply with all of the other requirements of the Convention. The main items to be covered under these inspection and certification requirements are detailed in the rest of this lesson. For convenience, they have been grouped under the three headings of Seafarers' Details, Working Conditions, and Living Conditions and Welfare. You should consult the Convention for more details of these and other requirements. The Convention specifies certain requirements to be met to ensure the suitability of people to work on board ships, including details about the seafarers. The seafarers' details that are subject to inspection under the Convention are the age of the seafarers, their medical status, and the qualifications that they hold. Click on the buttons for more detailed information on these items. The requirements for the minimum age of seafarers are covered by Regulation 1.1, the purpose of which is to ensure that no underage persons work on a ship. The main points covered by the regulation are that no person under the age of 16 years should work on a ship, and that no person under the age of 18 years should normally undertake night work, or work which is hazardous to their health and safety. The requirements for the medical certification for seafarers is covered by Regulation 1.2, the purpose of which is to ensure that all seafarers are medically fit to perform their duties at sea. This regulation requires that all seafarers hold a valid medical certificate which has been issued by an approved medical practitioner. It also gives guidance regarding the international guidelines that should be followed in carrying out medical examinations. The requirements for the qualifications of seafarers is covered by Regulation 1.3, the purpose of which is to ensure that seafarers are trained or qualified to carry out their duties on board ship. This regulation requires that all seafarers hold a relevant qualification or have appropriate training for the work they do on board the ship. The Convention specifies in detail the working terms and conditions that should be provided for seafarers on board ship. The areas of working terms and conditions identified as items to be inspected for compliance for certification purposes include seafarers' employment agreements, placement and recruitment services, hours of work and hours of rest, and the manning levels on ships. Click on the buttons for more detailed information on these items. The requirements regarding seafarers' employment agreements are covered by Regulation 2.1, the purpose of which is to ensure that seafarers have a fair employment agreement. This regulation details what should be included in seafarers' employment agreements and the rights that seafarers have in respect of the agreements. It clearly identifies the right for a seafarer to have the opportunity to review an agreement before signing it. It also gives the seafarer the right of access to fair and impartial advice regarding the agreement. and it also makes it compulsory for each seafarer to be given a signed copy of the agreement. The requirements for the status and operation of recruitment and placement services are covered by Regulation 1.4, the purpose of which is to ensure that seafarers have access to an efficient and well-regulated seafarer recruitment and placement system. This regulation lays out all the conditions that must be met by a recruitment and placement service for both public and private services. These services must provide fair opportunity for seafarers to obtain suitable employment corresponding to their qualifications and experience. A key requirement is that seafarers must not be charged a fee by these services for securing employment. In achieving the requirements of this regulation, it will be necessary for member states to set up some form of licensing or certification system of approved service providers. The requirements for seafarers' hours of work and hours of rest are covered by Regulation 2.3, the purpose of which is to ensure that seafarers have regulated hours of work or hours of rest. The maximum hours of work and the minimum hours of rest allowed in periods of 24 hours and 7 days are shown in the table. The regulation also requires that the hours of rest in any 24 hours must be split into no more than 2 periods, one of which must be at least 6 hours long. The interval between periods of rest must be no greater than 14 hours. This regulation also requires that either the normal hours of work or the normal hours of rest for seafarers are clearly identified and clearly displayed on a work schedule. This schedule should include normal rest days and also clearly defined a period of time to be considered as night time. Provisions must be made for suspension of work or rest schedules in the event of an emergency or other exceptional circumstances, and these must be recorded. Any special arrangements for seafarers under the age of 18 years must also be specified. The requirements for manning levels are covered by Regulation 2.7. The purpose of which is to ensure that seafarers work on board ships with sufficient personnel for the safe, efficient and secure operation of the ship. This regulation identifies the need to take into account any fatigue risk due to operational requirements when setting a safe manning level for a vessel. It also requires that each vessel is safely manned in accordance with the manning certificate in relation to numbers of crew and the qualifications held by them. The Convention specifies in detail the living conditions and welfare provision required for seafarers on board ship. The main areas under this section are the accommodation and recreational facilities, food and catering, health and safety and accident prevention, and onboard medical care. It is also required that systems are set up for dealing with complaints from the seafarers on board the ship and for the payment of their wages. Click on the buttons for more detailed information on these items. The accommodation requirements are covered in great detail by Regulation 3.1, the purpose of which is to ensure that seafarers have decent accommodation and recreational facilities on board. The regulation stipulates the very detailed requirements regarding crew accommodation, covering sizes, facilities and services which must be provided. The requirements of this regulation only apply to vessels constructed after the Convention enters into force for the flag state with which the vessel is registered. Existing legislation, such as the revised Accommodation of Crews Convention of 1949, will continue to apply to older vessels, unless they undergo major modifications. The requirements for recreational facilities are also contained within Regulation 3.1, which, as we have seen, deals mainly with accommodation issues. The regulation requires that appropriate recreational facilities are provided for the seafarers on board ship, without specifying the exact nature of them. This is left to the Member States' national legislation. Items recommended in the Part B guidelines for the regulation include facilities for fitness, for audio and video entertainment facilities, for libraries, for games, and for crew communications, as well as provision of a smoking area. As with all Part B guidelines, these must be considered by Member States, even though they are non-mandatory. The food and catering requirements are covered by Regulation 3.2, the purpose of which is to ensure that seafarers have access to good quality food and drinking water, provided under regulated hygienic conditions. This regulation requires that members ensure that all seafarers, regardless of their cultural and religious backgrounds, are provided with food and drinking water of appropriate quality, nutritional value and quantity. There should be no charge to the seafarer for this. Persons employed as ship's cooks must be over 18 years of age and be properly trained and qualified in the handling and preparation of food. In order to meet these requirements, the catering department must have the equipment and provisions necessary to ensure varied and nutritious meals are served in hygienic conditions. A system of frequent onboard inspection of the catering facilities carried out by the master or under his authority must be in place to ensure that the above requirements are met. The requirements relating to health and safety, including accident prevention, are covered by Regulation 4.3, the purpose of which is to ensure that seafarers' work environment on board ships promotes occupational safety and health. This regulation requires that members ensure that seafarers are provided with occupational health protection and safe and hygienic working and living conditions on board ship. These conditions should be in accordance with national and international guidelines covering occupational health and safety, including hazard risk assessment. The standard for this regulation includes the requirement to have policies and onboard programs in place covering occupational health and safety, and for precautions to be in place to prevent occupational accidents, injuries and diseases, and to have systems for inspecting, reporting and correcting unsafe conditions, and also states the obligation for all seafarers to implement and comply with these policies. The policies and programs must be continually reviewed, taking into account experience gained and technological advances. The requirements relating to onboard medical care are covered by Regulation 4.1, the purpose of which is to protect the health of seafarers and ensure their prompt access to medical care on board ship and ashore. This regulation requires that all seafarers have access to cost-free, prompt and adequate medical care on board ship, which is comparable to that available to workers ashore. These medical provisions should include preventative measures as well as treatments. It also requires that each vessel has a well-maintained medical chest and other medical equipment on board, including suitable medical publications and guides to meet seafarers' medical needs. For vessels operating in international waters for voyages of more than 3 days, which carry more than 100 persons on board, there is a requirement to carry a qualified medical doctor. Other vessels must have at least one designated person on board, medically trained in accordance with the amended STCW 78, in charge of medical care. Each member must also make available suitable onshore medical care for all seafarers on ships operating in their territories. This includes 24-hour-a-day medical advice. Further detailed recommendations given in the guidelines for this regulation cover inspection and reporting requirements and medical care and assistance for seafarers and their dependents. The requirements relating to onboard complaints by seafarers are covered by Regulation 5.1.5, which is part of Regulation 5.1, the purpose of which is to ensure that each member implements its responsibilities under this convention with respect to ships that fly its flag. Regulation 5.1.5 requires that all vessels flying the flag of member states have fair and effective procedures in place for dealing with seafarers' complaints. These procedures should be such that complaints are dealt with within a reasonable time frame. Seafarers must not be victimized for raising complaints, and the procedures should not affect the rights of seafarers to use other legal means to resolve the issues involved. In principle, the procedures should seek to achieve a solution at the lowest possible level, but also allow seafarers the right to complain directly to the master or to an external authority, such as Port State Control. Seafarers are to be issued with a copy of the complaints procedure and be given the opportunity to be accompanied or represented in the event of a complaint. The requirements relating to the payment of seafarers' wages are covered by Regulation 2.2, the purpose of which is to ensure that seafarers are paid for their services. This regulation requires that seafarers are paid the wages due to them on a regular basis. Payments should be made at intervals of no more than 1 month, and seafarers should be issued with an account of this, which at least shows the payments made and details of exchange rates that may have been used. Systems should be put in place which allow seafarers to have all or part of their wages allotted to their families on a regular basis and at a reasonable cost. The guidelines for this regulation give detailed recommendations which are to be considered when members draw up their national legislation to deal with seafarers' wages. Amongst other issues, these guidelines deal with overtime payments or compensation, calculation of rates of pay, consolidation of payments, and allowable deductions. The guidelines also deal with minimum wage levels for seafarers. In this lesson, we have considered the requirements for compliance with MLC 2006 with respect to the inspections that may be carried out by external authorities, and in particular, Port State Control officers. We have considered in some detail the 14 areas and the associated regulations that are mandatory requirements for inspection and certification. In the next lesson, we will look at the types of evidence relating to these 14 areas which will be required in order to demonstrate compliance during Port State Control inspections. Before moving on to the next lesson,